He's done advocacy work for several years and is very active. I'd like to introduce to you Mr. Ben Beveridge.
So first of all, thank you, David, for organizing this thing and putting it all together. I know you have a very busy job and family life, and it's really amazing that you put this all together, lined everybody up with the agenda together with everything you got going on. So what I'll be going over is basically some common objections to equal parenting that we've heard from some opponents to the bill, and it's objections that we've heard specifically here in Texas. I think going through these essential problems is a good way of learning the basic mechanics of what we're trying to propose to do in Texas. I do have an engineering background, so in school you learn a new formula, or you get some new plot to pressure drop against a fixed bed catalyst reactor. The best way to do it is start working problems, working examples, and your understanding will increase immensely. Before I start, I just want to say that since I will be talking about the objections that's come from the opponents to this bill, I'm just going to talk about for a minute who the opponents to this bill are. In other states, the opponents include National Organization for Women, Domestic Violence Group, things like that. We really haven't had a whole lot of that in Texas. In Texas, it's been basically the lobbying arm of the family law section of the state bar in Texas. They're called the Texas Family Law Foundation. And specifically what they are, they're a 501c6 organization. And what that is, it's a nonprofit that's formed to promote the interest of a given industry or profession. In this case, it's the family law attorney profession. It's an organization that consists of, I think, about 900 family law attorneys. That's about 1 in 6 attorneys in Texas. And they're basically the lobbying arm of the family law section of the state bar. So when they're up here, they're promoting the interest of family law attorneys. So that's where a lot of these objections are coming from, and I'm responding to most of those objections. So the first one we'll be looking at is one that bothers me and a lot of other people a lot. It really hits home. It's something that's been addressed already, and that's we already have equal parenting in Texas. This has come from the president of the Texas Family Law Foundation. They testified to this in a hearing before the JJFIC. It's come from various representatives of the Texas Family Law Foundation and educational seminars similar to this one. It's come from their head lobbyist, Steve Bresnan, on an official memo he sent out to the Capitol. Not only do they say we already have equal parenting in Texas, they say that if our equal parenting bills pass, a non-custodial parent can actually get less time with their kids, because currently, depending on when the holidays fall, the non-custodial parent actually gets more time than the custodial parent, according to the Texas Family Law Foundation. So, I come from, like I said, engineering background. When I hear the Texas Family Law Foundation saying that non-custodial parents are to get 47% time with their kids, I kind of want to reverse engineer it and see how they came up with this number, and there's a way that they came up with this number. So first of all, to set things straight, non-custodial parents don't get 47% time with their kids. The standard possession order is about 24% time. That's been calculated by myself and Michael Turry independently on an hour-per-hour basis. So, what we have is a modified standard possession order in Texas also, which extends the weekends from instead of going from Friday to 6 to Sunday to 6. The weekends will begin Thursday when the child gets out of school, and they'll end Monday when the child returns to school. But even if we look at the extended standard possession order, it only comes out to about 34% time for the non-custodial parent. So the question is again, where are they getting this 47% time? And it's the way they calculate time. This has already been addressed up here, but I'm going to give a little example. So let's take a 2-week period this section up here. So this is a 2-week period given a standard possession order. You have your 2 hours on Thursdays, 2 hours on Thursdays, that's 6 to 8 on Thursdays. And you also have Friday starting at 6, ending Sunday at 6. It's a total of 24 hours. So in a 2-week period, you have a total of 48 hours plus the 4 hours, 52 hours is what a non-custodial parent gets with their kid in a given 2-week period. So the way the Texas Family Law Foundation would calculate this is they would say, well, you get them 2 hours on Thursday, that's one day. You get them, although your day starts at 6 on Friday, we'll count that as another day. So, 2 hours the next Thursday, that's another day. So the way they're calculating it, they're looking at 5 whole days out of 14 days, and according to the way they would calculate it, you're looking at 36% time. That's over a 200% inflation over the actual reality. And I'm really kind of going to beat this dead horse a little bit because I really feel like this needs to be addressed. So, how do they get 47% time? Well, in an extended standard possession order, there's 173 days when the non-custodial parent gets time with their kids. And if you divide that by 365 days, that's where you get 47%. Now, there's been many members of the Texas Family Law Foundation, and we've asked them, how do you get 47%? They don't even know the answer to this question. They don't know where that number comes from. Okay? So, just on a just to add, insult to injury, the way this, if you did go this route, the proper way to look at this fraction would be not to divide 173 days you see your kids by 365 days in a year. It would be to divide 173 days divided by 443, which is the total amount of time that both parents see their kids. Okay, so I'm going to move on. Basically, there's no good explanation for this type of calculation at all. It does not give an accurate representation of the amount of time children spend with their parents, which is what we're trying to ascertain here. So how often is equal access actually awarded in Texas? Well, we took out to do our own study. We looked at Tarrant County in February of 2017, and we looked at 546 possession orders that occurred during that county, and basically what it came down to was 6% of those were equal parenting, and only 6% of those were expanded standard possession order. So this is a pretty large sample. The numbers across these numbers match the numbers in another study we did in Missouri County. I think it's pretty safe to say the percentage of equal parenting that occurs in Texas is about 6%, and the percentage of expanded standard is only about 5%. That leaves the rest of the orders being standard possession orders or less. Okay, so moving on, the number 2 objection is equal access would increase litigation. There's been studies to address this, but even without looking at the studies, you got to imagine that our current model, where one person is going to get the primary bulk of the parenting time, they're basically going to retain their status as a parent. The other parent is basically going to be reduced to a visitor. So this is kind of a winner-take-all scenario where parents are going to battle to be the winner. And you kind of think about it, if you take 2 people who are already kind of upset against each other, you put them in a room, and you put a bag in there with $80,000 and another bag in there with $20,000, and you say, hey, one of y'all are going to get $80,000, one of y'all are going to get $20,000. You can imagine it might be a bit of a scuffle. Now, take 2 bags in there, each with $50,000, almost guaranteed they're going to walk out, still be friends, So there's been studies to prove that equal parenting actually leads to less litigation. Number 3, proponents of equal access or equal parenting only want to reduce child support. This is the ad hominem attack. It attacks the supporters of a certain argument. It doesn't attack or address the argument. So let's not lose focus. What we need to decide is what type of possession order is going to be in the best interest of our child. One that initially starts off with allowing both parents equal access and then deviate from there, or one that starts off giving a huge discrepancy in time, in parenting time, and deviating from there. So let's not focus on, you know, what the child support is going to be or anything like that. Also, the child support guidelines don't even take into account possession time. You know, in Texas, if you calculate the child support for a non-custodial parent, you look at how many kids they have and how much what their net income is, and you determine their child support. Equal access would restrict a judge's discretion. So right now in Texas, the judge has very little discretion. Section 153.252 of the Texas Family Code puts a rebuttable presumption for a standard possession order. The judge can only deviate from a standard possession order if basically the would-be non-custodial parent can produce enough evidence to rebut this presumption. The next section of the Family Code, 153.253, it actually says that if the judge does deviate from a standard possession order, he will deviate it from as little as possible, and he will put in an order that as similar as possible as provided by the standard possession order. And guys, listened to Mark Ledwood speak yesterday, and he had a presentation. It was given yesterday, so Thursday, and he mentioned that someone made a comment to him that, well, you know, someone has their kids, you know, that's the time for non-custodial parents to have their kids, 6 to 8 on Thursdays. And Mark made the comment, well, you know, that's just one parent. He said, no, every non-custodial parent in Texas has their kids on this day from 6 to 8. And he said, you know, wow, that's such a cookie cutter, you know, one size fits all application. And the fact is, in Texas, well, Texas is one of the few states that has codified a standard order. Many other states, the judges have a lot more discretion. So, equal access, it won't restrict a judge's discretion. What we have now extremely restricts a judge's discretion. 5, equal access would force children to live out of a suitcase, and it's very confusing for them. They have to learn the rules of both households, and it's just not good for them. So, standard possession order, our current standard possession order, the most prevalent possession order in Texas, you have 12 to 14 exchanges with where the kids are going back and forth between households. 12 to 14 exchanges in a month. The typical equal parenting possession order is a week-on, week-off possession order. There you're looking at 4 to 6 exchanges. So much less exchanges with most equal parenting orders. And if you notice the standard possession order, none of the exchanges are made at school. They're all made from parent to parent. So if you have parents with high conflict, then the child can potentially be exposed to this high conflict at each and every exchange. Whereas equal parenting orders, they can be made to where the exchanges take place on Monday. So one of the parents would drop the children off at school on Monday, the other parent would pick them up on Monday, virtually eliminating, parent-to-parent interactions. Shielding the child from any conflict that there might be. There's also been a study to show that children, if they go back and forth between their parents' house, this study looked at, it's called 50 years a move, 50 moves a year. Is there an association between joint physical custody and psychosomatic problems in children? And they found that there is not. There is no detriment caused to a child by switching households, going back and forth. The idea that children can't adapt to the different rules in the different households is kind of hard to comprehend. If you think about your children going to school every day, obviously different rules at a school, they go into different classes. This is something that children can easily adapt to. Conflicting parents won't be able to make their decisions together. Equal parenting in Texas addresses physical custody. This is known as possession in Texas. Physical custody is different from legal custody, which is known as conservatorship in Texas. Conservatorship in Texas deals with the rights and duties of each parent. Conservatorship determines who makes what decisions with regard to educational decisions, medical decisions, anything like that. So, making equal parenting possible in Texas is going to change the physical custody, it's going to change the possession aspect, not legal custody, not the decision-making aspect. That part remains unchanged. Okay, what if parents live far apart? Well, there's no equal parenting bill that I know of that is a presumption for equal parenting. It's always a rebuttable presumption for equal parenting. So obviously, if parents live too far apart, that's probably going to be the number one situation where equal parenting doesn't work, and the judge can simply exercise his discretion, say this is not going to be in the best interest of the child, and put in a possession order that will work. So just because some parents live far apart and equal parenting will not work, don't throw out every situation, even for the parents that do live close together. Don't throw out the baby with the bathwater. Statutorily, Texas Family Code already distinguishes the type of possession orders that can be put in place based on whether or not the parents live within a 100-mile radius of each other. So statutorily, that will likely remain in place anyways. Equal access offers no standard schedules. Well, you know, exactly, we want to give the judge more discretion, but there are several schedules that, that judges, when they do order equal access, they already know the schedules to rely on. You have every other week a 2255 schedule. These are standard equal parenting schedules that all judges in Texas are already familiar with. Parents who agree can already get equal access. Very few parents agree in a divorce. That's you know, part of the reason why they're getting a divorce. So, and once again, when you have this win-lose situation, usually one of the parents has a pretty good idea that they're going to win if they go to court. So the motive to settle is not really there. They're pitted against each other in a winner-take-all battle. And yeah, about 50% of the visitation schedules in Texas are ordered through settlement agreements through the Office of the Attorney General. And only about 1% of those orders are equal parenting. The other 99% are standard possession orders, or orders where the non-custodial parent gets minimum possession with your children. And most of the people that settle in the Office of the Attorney General are people with lower incomes, people who can't afford attorneys, who aren't confident enough to go to court. So what that leads to is if you're a child with a low income, from a low income family, there's a much greater chance that you're going to get minimum time with your non-custodial parent. Lost my clicker function. Can you advance? Bear with me 1 minute, I'm almost done. Okay, just the general argument that there's no empirical support for equal parenting. Both of these studies I'm briefly going to talk about have already been mentioned. These are the two strongest studies for equal parenting. One, we have Dr. Linda Nielsen from Wake Forest University. What she does is she regularly goes out and she looks at, she does a search through all the English academic journals and government records, and she finds studies that compares the effects of different visitation orders on children. So, you know, these studies, you know, the best way to find out if equal parenting is in the best interest of children is obviously take a group of children that's been raised, who's had equal access to both parents. You take another group of children who they primarily live with one parent, And then you look at their educational outcomes, you look at their physical health, their mental health, you know, their ability to, you know, form relationships and all these types of things. And what she does is she goes and she looks at all these studies, and right now she's up to about 60 studies, and in only 6 of those studies have the children in equal parenting not fared better than the children in a primary residence model. So for someone to say that there's no support for equal parenting, they're just not looking. I mean, you know, like I said, 60 studies, and she doesn't pick and choose. Every study she can find, and out of 60, only 6 of them, the children don't fare better in an equal parenting situation. The other major study is by Dr. Warshak out of UT Arlington, I believe, and he's put out, he's basically put out a study that it's an endorsement for equal parenting, but it's more than that. He's gotten 112 social scientists to basically sign on to this study. And out of the people who've signed on to this study, you have 2 former presidents of the American Psychological Association, 5 deans of universities, and just individuals who have spent their lives basically studying the effects on children of different custody orders and whatnot. And they've all signed on to this study, and basically the findings were that children fare best when they have equal access to both parents, and it's actually a detriment to children if they have less than 7 days a month with their non-custodial parent. Now what's unique about these studies is these are consensus studies. These are where a group of social scientists have got together, or one scientist has looked at a whole group of studies, and they're essentially screaming at us, you're doing custody wrong, this is detrimental to our children. I mean, you can't go to another field and find this large amount of consensus studies. These are just a few of them. There's many more consensus studies called meta-analysis, where a researcher will look at several studies and see if there's any consensus. They always find there is a consensus. Equal parenting is in the best interest of children. Go forward one more. Okay, so to be fair, our opposition, the Texas Family Law Foundation, you know, there's studies that support their point of view also. Their study was put forward last legislative session when they held an educational seminar. I'm just going to briefly go over their study. So what they did, they did a case study, and there was a 13-year-old child, and there was a primary residence model, not equal parenting. There was high conflict, and basically they found out that, you know, this type of model insulated the child from high conflict. The child fared better in this primary residence model. And then they had another case study where they had 2 children. Parents had 50-50 equal parenting. There was high conflict, and this was very bad for the children. Now, it doesn't necessarily say who did this study. I don't know that it's been published in any peer-reviewed journals. I would think 2 families is a pretty small sample size when you have so many other studies to choose from. But this is what they got. Okay, can you advance it one more? The last one I want to address, I didn't put it in here, but you hear things about like abusers might get, you know, well now abusers are going to have equal access to their kids, and people that commit domestic violence are going to have equal access to their kids. Well, the same protections that are in place right now to prevent kids from that sort of things are still going to remain in place. So that's my presentation. Thank you for listening, everybody. I know we're running.
Are there any questions from the audience, please? Yes.
Thank you, Ben. The question that I have is, when you talk about judicial discretion, and something that maybe piggybacks a little bit with what Mark said, in the Texas Family Code in section 201-107C, it says that the presiding judges and the Title 4D agency shall act and are authorized to take any actions necessary to maximize the amount of federal funds available under the Title 4D program. So what I'm hearing, and correct me if I'm wrong on this, is that there's almost an incentive, or the Texas Family Code actually almost mandates something other than shared parenting, because if you have a model other than that, the primary residence model, you can maximize the funds, the Title 4D funds. Is that a valid conclusion?
Yes, I think so. And, you know, regarding giving discretion, it sounds like the legislature is basically telling the judges they have discretion to put in any order and to make any decision that will maximize Title 4D funding. And the only thing that should be on the judge's mind is what's in the best interest of the children. And as social scientists are in a consensus about, that's having equal access to both parents. Did I answer your question?
So the best interest of the children almost looks like it's the best interest to maximize funds then.
I would agree with that.
Okay.
I want to ask, following up on his question, and maybe Mark can answer better than anybody else. When I've looked up the actual public law of 4D funding, it says absent and deserted children. Where and what authority does anybody have to change absent and deserted to custodial and non-custodial in the codified law?
You're absolutely right. It's the typical government outreach or overreach of a.
Well, I mean, you even said it, the mission statement, and Sessions came out and said guidance documents are not law. So we have a law that says absent and deserted. Where does any public official have a right to change abandoned and deserted to custodial and non-custodial?
I think my short answer to that would, and this is without looking at any case law or the statute or anything, my guess would be in our common law system, some judge somewhere has interpreted abandoned.
No. It's in the past bills, in the bills of the Senate, in the bills of the Congress, signed by the President of the United States. It says deserted and abandoned. When you look up 42 USC, and it changed abandoned and deserted to custodial and non-custodial. The two are totally opposite of each other.
Yes, I agree. I don't know, I have to look more into that, but maybe we can talk afterwards here in a little bit and get to the bottom of it. Thank you.
Ben, thank you very much.
Just really quick, Ben, you said 7 days with Dr. Warshaw?
Yes, he said any time where a child gets less than 7 days a month with their non-custodial parent, that crosses the line of actually being detrimental to the child.
And that was signed off by the APA?
That was one of their policy recommendations in that consensus study signed off by all 112 of those social scientists.
In addition to that, actually, there were two separate reviews that Warshak did. He introduced his review of the literature, which was a complete review. What he did subsequently, he sent it out to 110, 112 researchers around the world that were experts in child development. They gave his consensus. Then he republished a second review to include that. Can I get your help on those slides? Because I want to go back to a couple slides. Speaking of the literature in context of the empiric support for shared parenting, one of the other important things that I discovered in Dr. Nielsen's review is she found out that in previous reviews, and some of these reviews were actually used by opponents of shared parenting, that in previous reviews, actually, the reviews by the researchers didn't include all the available ones at that time period. And what she included was very poignant in stating is that reviews that were used were selected out in order to oppose the issue of equal time. In addition, what she pointed out, she was very direct in her paper, that there were particular reviews that actually misquoted the research. And when you look back in detail form of the research, what the research concluded was that the issue of what we would call shared parenting or equal access actually did not lead to increased conflict, but actually increased to a level of decreased conflict. So those are just some points offhand of Ben's lecture. I appreciate you, Ben. Thank you so much.